Roughly, there has been quite a lot of delay, quite a bit of delay uh, since my last reading. It was essentially my mother passed away, and also my looks have changed. This is a show with Rolagiri from guide2ibc.com. My looks have changed basically because my mother passed away on 31st of March. And in between, there was Shraddha and other things, the last rites. So the delay in doing any podcast. Now, today, with time being limited, and in between, since the last video, quite a lot of time has passed by, and there has been a lot of judgment. If you try to talk about such judgments, all the judgments, it will become a huge video and which will take a lot of time. So I've selected 10 cases on which I'm going to discuss. These 10 cases are not, I don't call any case, or all cases are cases, because I find them interesting. In all cases, there's something new or the other in every case. So from that point of view, I think I've just selected 10 cases which may interest you and which I feel will have an impact in future, um, especially pertaining to Insolvency and Bankruptcy Code, and which may help us in learning the code better. Now, let me share the screen with you. So you can see guide2ibc. So the first case we want to discuss about is in the definition, section 3, subsection 6, which is claim, and number 1. The basic element of a claim is direct privity of contract between the corporate debtor and concerning corporate debtor concerning the present alleged debt. This is a case, NCLAT case, Onindo Infrastructure Private Limited versus Shubhamna Building Private Limited, which happened very recently, 2021. Don't get misguided, it came out a few days back only. So if you go into the case, you will find that I'm just looking at the headlines. The receipts were to be distributed amongst appellants and the appellant and the respondent in the ratio of 50% each on daily basis in their respective accounts after paying first 2.5 crores to the appellant from the escrow. The escrow account was to be opened by the developer within a period of 2 weeks from the date of development increment, which happened on 6/8/6. Yeah, 6th of March 2010 or something. I think there is a typing error, which was never. So now the purported forming the basis of appellant's claim in reality was owed to the sister concern of the corporate. So the appellant here, person who has lent money, actually had paid money, had given money to the sister company of the corporate debt. So thus it is inferred that the appellant does not have necessary direct privity of contract with the corporate debtor concerning the present alleged debt. There is no um, borrower-lender connection directly between the lender and the borrower. It was with the sister company. So the joint development agreement dated 6/2018 was never acted upon, rendering the appellant's claim unsustained and legally untenable. From various pleadings and correspondences exchanged between respondent 1 and resolution professional, the appellant, it seems that the appellant failed to establish its claim. Obviously, because if you have given money to a sister concern, then you will not be able to prove any privity of contract between the buyer and lender relationship will not establish. So automatically, this will not really, the claim will not substantiate. And what is a claim? Claim means a right to payment, whether or not right is reduced, which when fixed, disputed, undisputed, legal, equitable, or unsecured. The right to remedy for breach of contract under law of time being enforced if such breach gives a right to payment, whether or not such right is reduced to judgment, matured, unmatured, disputed, undisputed, secured, or unsecured. Now, the basic question is there has to be a borrower and a debtor. Now, if the money is given to a third party, whether sister concern or whatever, then there is no privity of contract. So, as such, this is an important case which we should bear in mind. Whenever there is a claim, we are getting a claim or a Section 7 or Section 9, whatever, we have to keep it in mind that there is a privity of contract. Else, the claim will not substantiate. Now, we come to 312. What is default? Now, this is a very recent case. It is also topic number one. The company having not earned profit, the preference share allotted could not be redeemed. Thus, there existed no default. Well, let us see the case EPC Constructions India versus Messrs. Matrix Fertilizers and Chemicals Limited, Company Appeal 1424 of 2023. The judgment came out only a few days back. Now, what it says that the demand was issued by the resolution professional for the matrix on 25 for rupees 632.7 crore, which also included 310 crores towards CRPS, and it was thereafter Section 7 application was filed. Section 55 of Companies Act 2013 provides that no such shares shall be redeemed except out of the profits of the company, which would otherwise be available for dividend or out of proceeds of fresh issue of shares made for the purchase of such redemption. So a preference share can be redeemed out of profits of the company or by making another fresh issue. So once that is not done, the default cannot be said to have arisen. In fact, in one of the Bombay High Court judgments, it was stated that holder of preference share does not assume the character of creditor. But this does not really apply in this particular case. It's as per the agreement. The shares were supposed to be redeemed. The company was, but adjudicating authority found that the company is not making profit. The findings of the adjudicating authority is that the preferential shares being not redeemable, the company having not earned profit, or there were any proceeds of fresh issue of shares made for the purpose of such redemption. NCLAT fully concurred with the findings of adjudicating authority that there was no existence of default on the part of the respondent so as to admit Section 7 application. So, the default did not arise. The default could have arisen had there been profits in the company. Since there was no profits in the company and there was no fresh issue of shares for the purposes of redemption, so the question of redeeming the preference share never arose. And so the preference share, though they claim, but that claim there was no default. So the default could not be established. And this is an important aspect. This is an important aspect. We need to, because entire IBC is based on debt, default, and claim. So we have just now discussed on a case pertaining to claim, and now we have discussed a case pertaining to default. So these are intricate issues, and it is necessary that we should have clear idea about this. So let us switch topic and go to Section 10A. There have been some very good judgments in 10A of late. I'm sorry, I'm having a little cold and cough. I hope by now you are conversant with to navigate the site. Now we come to topic 21. Topic 21 says default part of guarantor that only grants when the guarantee is invoked. If the invocation happened during 10A period, Section 7 petition cannot be considered. So we know we have a very fair idea about guarantee invocation. We have seen in personal insolvency also. NCLAT has stated that uh, application according to Rule 7, uh, petition under Section 95 can only be invoked if the guarantee is invoked. And we have had earlier cases also in pertaining to Section 7 also, in which we found that it is, before making the demand, you have to make the invocation. Now, if the invocation happened during the COVID period, this is a case IDBI Bank Limited versus Re Entertainment Enterprises Limited. This is a case of number 939 of 2023. Now, the period from 15/3/2020 to 28/2/2022 stand excluded for the purposes of limitation, which this we all know as per suo motu order of Honorable Supreme Court. We stand excluded. Now, for default committed, for default being committed within Section 312 of IBC, the amount should be payable and is not paid by the debtor or corporate debt, by the debtor or corporate debtor. And the date of default of the principal borrower as guarantee shall depend on the contract of guarantee. Default on the part of the guarantee can only arise when guarantee is invoked. When the appellate financial creditor has come with a categorical case, mark the phrase categorical case, that the guarantee was invoked on 5/3/2021, there cannot be any occasion to treat any other date as invocation of guarantee. So the guarantee was invoked on 5/3/2021, which is very much within the period of 15/3/2020 to 28/2/2022. Now we know that as per suo motu order, no proceedings can be initiated for any default arising in this period. So obviously, this was not considered. I mean, the adjudicating authority thus cannot be said to have committed an error in coming to the conclusion that Section 7 application filed by the corporate in PNA. However, liberty needs to be given to the applicant, if so advised, to file Section 7 application for default of corporate debtors subsequent to 10A period. That is default subsequent to 24/3/2020. Here, what happened? IDBI Bank stated that the default is continuing. There are interest and other things remaining. So, in such case, whether they should be permitted. So, the court said yes, liberty is given to you. But as far as this particular application is concerned, it is barred by delay. So I found this to be an interesting judgment which we could discuss. And let us go to another judgment of 10A only. This is also a very recent judgment of Vinod Kumar versus Omkara Asset Reconstruction Private Limited. This is company up in 2265 of 2024. The topic says prohibition to initiate Section 7 application for default under Section 10A period cannot mean liability is wiped. You're only debarred from proceeding against the debt, but the debt is not wiped. The interest of the outstanding amount of the CD shall not come to an end. The interest will continue. And that you cannot say that because, okay, the debt is within the COVID period. So, okay, you cannot go for that. But what about the interest, which keeps on accruing? In this particular case, which was originally of IndusInd Bank, if I'm right, this was assigned to Omkara. So there is no dispute between the parties that period of 48 months after extension came to an end on 11 to 2021. Thus, the date of repayment of 300 crores fell on 11 to 2021, which admittedly is a debt which falls within 10A period. The prohibition to initiate Section 7 application for default under Section 10A period cannot mean that the liability is waived. If the outstanding amount continues even after 10A period, the interest liability on outstanding amount of the CD shall not come to an end. The interest will accrue. And if the interest, in the present case, however, it is founded on the basis that even after the end of 10A period, the CD defaulted in obligations to pay monthly interest and the liability of interest from 2020. With this, I have a little doubt about the dates, which is more than 9.38 crores. Though it is mentioned in the order, I have a little confusion pertaining to the date because these two dates come within the 10A period. But the factum is for interest accruing on debt which has matured on during COVID period. If the interest is accruing, the interest is not in such case. You cannot say that 10A period will take care of the future interest. And because the essence of 10A is that you cannot initiate any action, but the debt remains. So this is an interesting case. Now let us come to section 14, which is this I found to be an interesting case. This is indeed an important case. Why? The case of Pratibha Industries Limited versus Yes, in which it is said that the right of redemption under section 14(1)(c) does not exist if notice of sale under section 13 subsection 8 of SARFAESI Act precedes CIRP commencement date. Now, in this particular case, NCLAT stated that in Indian Overseas Bank versus RCM Infrastructure, civil appeal number 47502021, which has only interpreted section 41 of the code and does not apply because section 13(8) of SARFAESI was not brought to the notice of honorable court. So what was this case of Indian Overseas Bank versus RCM Infra? Let us go back a little bit. Moratorium includes prohibition of transferring, encumbering, alienating, or disposing of by the corporator of any of its assets. Indian Overseas Bank versus RCM Infrastructure, Supreme. So herein what happened was SARFAESI sale had taken place, but the deed was yet to be executed. The last payment did not. The last payment came after the commencement of CIL. So Supreme Court said, since you have not received after before commencement of CIRP, the moratorium was in place, so the transaction wasn't complete. In this particular case, Pratima Industries, Honorable NCLAT said that in Indian Overseas Bank versus RCM Infrastructure Limited, Civil Appeal number 4750, which has only interpreted Section 14.1 of the Code, does not apply because Section 13.8 was not brought to the notice of Honorable Court. Now, a question may come to your mind. It came to my mind also, because there is an obstacle clause we have under Section 238 of IPC. NCLAT has not discussed about that, but we are not legal experts. So, since NCLAT has said this, this is a recent judgment, so it is better we keep this in mind. Bank itself purchased the first property, which is permitted under Section 13.5A and 13.5B of it, and adjusted the amount which it had recovered from the city. The junior relationship between the parties in respective states of holding also came to an end. Also came to an end. I mean, also came to an. I'm sorry, there was a came to an end on 3/1/2019 or 28/1/2019, which was much earlier than the date of commencement of CRP, 1/2/2015. In this case, even the letter of confirmation was issued on 28/1/2019. The same certificate was issued on 3/1/19, which was much before the date of commencement of CIRP on 1/2/2019. So much before is 2 days, 1 day, 1 day or 2 days before. Right? So if you look at it from Indian Overseas Bank versus RCM Infrastructure, yes, this contradicts. But then court said, NCLAT said that in one particular case, Honorable Supreme Court did not consider Section 13.8 of SFAC. So they are of the view that SFAC Act of that subsection 8 of Section 13 of SFAC Act will prevail over 14.1 of IBC. So the contention of the appellant that non-deposit of the sale consideration in the estate of CD affects the right of the secured creditor is go away. So this particular case being, since it is contradicting Supreme Court judgment, we have to keep in view, it is better to keep both the cases in view. Because ultimately something or the other will prevail. So until or unless Supreme Court comes up with another judgment. So this case will prevail for the time being. Now, let us switch over to Regulation 31. The Regulation 31 is an important case. The topic says a CIRP under Regulation 31B. CIRP cost under Regulation 31B can only be claimed if the rights or interest of the person is prejudicially affected on account of moratorium imposed under Section 14.1. Now, in this particular case, there were many cranes which were lying in the premises of the CD, and they had said that their right, they could not obtain the lease rent of the crane, and Because of moratorium, their rights were affected. So the court was of the view that it is the present was a case where cranes were never in use and the resolution professional never permitted the use. So during the CRP period, the cranes were never used. It is not even disputed that cranes were not used in the project of the corporate debtor, being not a going concern. Regulation 31B provides that amounts due to a person whose rights are prejudicially affected on account of moratorium imposed under 14(1). The present is a case where admittedly the appellant, was not receiving any higher charges or rent with regard to the cranes for several years. Admittedly, after June 2018, no invoices were issued, nor any amount of hire or rent were received from the appellant. Thus, the mere fact that the moratorium commenced after 2024 would not be said to be prejudicially affecting the interests of the appellant. So the submission of the appellant that under Regulation 31B, higher charges should be treated as CIRP cost cannot be accepted. So, in order to claim CIRP cost under 31B, you have to prove that your right is prejudicially affected moratorium, because of moratorium coming into place. In this particular case, like claims were there existing since long back. So there was no way we could say that their rights were prejudicially affected. Now we come to another case, that is, we go to liquidation. Before, going concern means a going concern in two senses. Now this is the case of Busy Bee Airways Private Limited versus Dinakar P. Venkata Subramaniam. Appeal number 124, 175, 244, 2025. Regulation 39C. The decision of COC taken in the 37B was clearly in exercise of its power vested in the COC under Section 33, subsection 2. COC with 100% voting right had decided to liquidate the corporate debt. Now, while liquidating, how the assets will be sold were also considered by COC. Regulation 39C1 requires COC, while deciding to liquidate CD, the committee may recommend that the liquidator may first explore the sale of CD as a going concern, or under Clause E, Regulation 32 of IBBI liquidation regulations, or sell the business of CD as a going concern. COC in its 37th meeting has averted to the questions as to whether CD can be sold as a going concern. The COC was of the view that liquidators may sell assets on a standalone basis, assets in lump sale, a sale of assets collectively, and assets in parcels, and not wait for selling CD or its business as a whole. So the COC was very much aware that the CD was not a going concern, and accordingly, they did not adopt. So when you are proposing to sell a going concern should essentially mean that the company is a going concern, or on sale it will become a going. But essentially, if we go by the case law, it doesn't say so. If we go by the case law, it says that the CD should be a going concern on the date of commencement of CIR. So here COC in its commercial wisdom decided that the CD's assets should be sold on slump sale basis or collectively or assets in parcel. Don't wait for selling CD as a going concern or business as a whole. Since the COC, however, observed, however, in the event for suo motu proposal is received from any person by the liquidator for taking the company or his business as a whole, the same can be explored in discussion with the stakeholders consultation committee. So this entire decision was perfectly legal, perfectly logical, and it took into view that company is not a going concern. But in case somebody would come and say that yes, they are ready to take it as a going concern, then then the liquidator in consultation with the SCC can decide. Otherwise, they can go and sell it on in the manner as decided by the COC as per Regulation 39C. So this is an important case. We invariably we tend to think that going concern sale should be most preferable. It is. But then there is a logic. And Easy Being Airways Limited, Private Limited is a new case, and I think it's an important case which you should consider. Now let us come to an important case pertaining to Section 61, 16. The limitation starts from the date of pronouncement order and not from the date the order is made available. Yes. This is a case of A. Rajendra versus Konugunta Madhusudan Rao and others. Of Supreme Court. Civil application number 11070 11071. The essence of case is that case analyzed that NCLAT, that is the appellate authority, works within a limited frame of rules and laws. And that the law, as per section 661, they can allow an appeal to be submitted within 50 days and they can allow an extension, maximum extension up to 15 days. Now here the Supreme Court observed that section 61 begins with a non-obstante clause signifying an overriding effect of this provision in case some contradistinction with the contents of contemplated in Companies Act 2000. Statutory limit of 30 days within which an appeal can be preferred has been provided for in subsection 2 of section 61 of IBC. Restrictions with regard to allowing extension in the provision stipulated is cloaked in such a manner that provision needs to be strictly followed. So it is not as per whims of the court, it has to be strictly. So there must be a logical reason for asking for extension, for availing extension of 15 days. It doesn't come as a matter of right. Additional 15 days cannot be claimed as a matter of right for extension of the limitation. Rather, it is laced with the satisfaction at the end of NCLAT upon having shown sufficient cause. Sub-rule 2 of Rule 22 of NCLAT rules thereof mandates that appeal shall be accompanied by certified copy of the appeal order. So, ultimately, the court came of the view that it is the date of pronouncement, the incident which triggers limitation to commence is the date of pronouncement of the order. And in the case of non-pronouncement of the order, of the hearing order, When the hearing concludes, the date on which the order is pronounced are uploaded on the website. So this is 30 and 15 days where from it starts, where from it ends. And power of NCLAT to allow 15 days extension also. But after they can only allow it after being shown sufficient cause. So this is an important Supreme Court case, very recent. So let us now go to individuals and quickly wind up two cases. In the first case which we take up in this particular case, I am also involved, but my name is not there. But I was on the RP there. The scheme as delineated under section 99(1), 4, 5, 6, and 7. It is clear that submission of report within 10 days from the appointment of the RP is only directory and cannot be held to be mandatory. Suresh Atlani versus Omkara Asset Reconstruction Private Limited. Company appeal number 235. As I told you, I am the advocate of the matter. Now, what the court has observed in the scheme delineated under section 99(1), 4, 5, 6, and 7, it is clear that the submission of report within 10 days from the appointment of RP is only direct and cannot be held to be mandatory. RP filed the amended report due to the reason the response which was called for from the financial creditors was received only after submission of the first report, and supplementary affidavit was filed by the RP. And it is further relevant to notice that both reports were taken on record by the adjudicating authority by 324. The period of 10 days provided for submission of the report method is not a period of limitation prescribed for doing the act. So Limitation Act does not apply here, which is very important at 10 days. And this is this being now the PG cases are there. So here it now becomes very clear that RP, though it is RP should try to file the report within 10 days, but it is not a mandatory requirement. Now let us quickly wrap up the presentation with the last case. Five, during the stages of 95 to 100, the debtor is not at all deprived of an opportunity to participate in the process of the examination of an application by resolution. This is the case of Iqbal Jumna Bhoy versus C. Manoj Kumar and another. Company appeal is a Chennai case of 2934 of 2025. So you see, whatever cases which we have, the framework of personal guarantee is essentially determined in the landmark judgment of the case. And all that we are seeing is the development is subsequent to the PGR as per the guideline laid. So the use of the expression therein, such as examine the application, satisfies the requirement, recommend, leave no doubt the resolution professional's report under section 99 does not have any element of significance. The resolution professional does not have any kind of power which the learned adjudicating authority has. No power has been provided to the resolution professional under the provisions contained in 3 of the code to take over the assets or the business. So in insolvency, RP has no right as to RP in any case has no adjudicating power. He's just making a report under section 99. And The fact is, the need for adherence of principles of natural justice at the stage of Section 99 has been considered by honorable Commissioner. It requires that a reasoned order is to be passed by on the recommendation contained in the report of resolution professional, and as it is likely to affect the concerned individual. There is no violation of natural justice under Section 95 to Section 100. And during these stages, debtor is not at all deprived of an opportunity to participate in the process of examination of an application by resolution. Numerous opportunities were given to appellants to furnish necessary information. This is not important. But what is important is that natural justice in PG cases very much prevail. They have the right to object. The report of RP is subject to be, it is not a final report. RP is only a facilitator. So between the stage of 95 to 100, there is enough opportunity on the part of the personal guarantee to participate in the proceeding. So there is no violation of natural justice. With this, as you can see, this entire funeral and other things have a little bit affected my health. Also, my features are a little bit, with shaved head and all that. Hope you'll excuse that and a little bit of coughing, which interrupted now. But we'll again in the next week, now that things are normalizing. Next week is going to be full holidays. So week after that, we'll again come with another, to put up another video. And let's hope in between, happy, we'll go on enjoy the long weekend. Thank you so much. Bye for now.